Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some new legislation and agency rulemaking. The California legislature is currently considering Assembly Bill 67, also known as the Double Pay on the Holiday Act. If enacted, this bill would require California employers to pay at least 2 times the regular rate of pay to an employee for a work on a family holiday. Family holiday is defined by the bill as either Thanksgiving or Christmas. The bill is currently being considered by the Assembly Labor and Employment Committee. The Department of Labor has issued a final rule revising the definition of spouse under the Family and Medical Leave Act, or FMLA. Previously, the FMLA determined spousal status based on the employee's place of residence, which effectively deprived same-sex employees from qualifying as a spouse if they lived in a jurisdiction where same-sex marriages were not recognized. Under the new rule, eligible employees in legal same-sex marriages will be able to take FMLA leave to care for their spouse, regardless of where they live. Employers must provide FMLA leave for eligible employees in marriages that were valid in the place in which they were entered into, whether those marriages are same-sex, opposite sex, or common law. The new rule went into effect March 27, 2015. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In Swanson v. Morongo Unified School District, a California Court of Appeal held that the trial court erred in granting the employer's summary judgment motion, finding that the plaintiff had sufficiently raised triable issues of material fact with respect to her claims for disability discrimination, failure to provide reasonable accommodation, and failure to engage in the interactive process. Laura Lynn Swanson is an elementary school teacher with over 30 years of teaching experience. In August 2006, Morongo Unified School District hired Swanson as a technology reading specialist and computer laboratory teacher. She received excellent performance evaluations. Nonetheless, her school's principal, Principal Lowe, changed her teaching assignment to a language reading specialist for the 2007-2008 school year. In the summer of 2007, Swanson was diagnosed with breast cancer and underwent a mastectomy. Swanson advised Principal Lowe of her health condition and expressed concern about the lacking in the necessary training to excel in her new placement. Swanson managed to attend 5 days of training 2 weeks after her surgery, but was sent to the emergency room because of surgical complications. Swanson postponed her cancer treatment to prepare lesson plans for her replacement and went on medical leave from October 2007 to March 2008 to undergo chemotherapy. Principal Lowe initially assigned Swanson to teach 5th grade for the 2008-2009 school year. Swanson objected, arguing that her health condition would prevent her from doing the necessary preparation for a new assignment. Swanson requested a vacant 2nd grade teaching position, as she previously taught 2nd grade in another school. However, Principal Lowe gave the 2nd grade position to another teacher and assigned Swanson to teach kindergarten, even though he knew she had not taught kindergarten in over 30 years. Swanson expressed her concern that teaching kindergarten-aged children would expose her to many illnesses and pose health risks because her immune system had been compromised during treatment. Principal Lowe did not change her assignment. In September 2008, Swanson was hospitalized for 8 days with pancreatitis, pneumonia, and liver issues that she attributed to her kindergarten teaching assignment. She was not able to return to teaching until December 2008. Upon her return, Principal Lowe scheduled observations for her annual teaching evaluation. Thereafter, he gave her a poor performance rating and provided her the choice of resigning or participating in a remediation program. Swanson chose the latter. However, before her remediation plan observations were complete, the district's Board of Education voted not to renew her contract for the 2009-2010 school year. Swanson filed suit alleging that the district discriminated against her because she had breast cancer and took a medical leave of absence, failed to reasonably accommodate her disability, and failed to engage in the interactive process with her. The trial court granted summary judgment on all of her claims. Swanson appealed. The appellate court held the trial court erred in granting summary judgment as to the discrimination claim, emphasizing that the district bore the initial burden to negate an essential element of Swanson's prima facie case or establish a legitimate, non-discriminatory reason for terminating her employment. Swanson argued that the district set her up for failure by giving her a difficult assignment without the resources required to succeed so that she could be discharged based on her poor performance. The appellate court held there was sufficient evidence presented to create a triable issue on Swanson's theory. As to Swanson's reasonable accommodation claim, the appellate court found that the district failed to meet its burden to show that the second-grade position sought by Swanson was not available or was not a reasonable accommodation. The Court of Appeal also stressed that an employer has a duty to reassign a disabled employee if an already funded vacant position at the same level exists, and that a disabled employee seeking reassignment is entitled to preferential consideration over other applicants. In this case, the district gave the vacant second-grade teaching position to a non-disabled teacher when Swanson should have received preferential consideration. The Court of Appeal also found that the district failed to show that it continued to engage in dialogue regarding accommodations. The appellate court emphasized that an employer has a continuous obligation to engage in the interactive process in good faith and can be held liable if it is responsible for a breakdown in the process. Despite the district's past efforts to communicate with Swanson and identify reasonable accommodations, the district did not prove that it engaged in ongoing dialogue with Swanson regarding the second-grade teaching position. This case serves as a reminder of employers' obligations to engage in the interactive process and provide reasonable accommodations to disabled employees. Employers should have a system in place to document all reasonable accommodation requests and should engage in an ongoing dialogue with disabled employees. In Augustus v. ABM Security Services, a California Court of Appeal held that an employer's obligation to relieve employees of the obligation to do work on the employer's behalf during rest breaks is not as far-reaching as prospective plaintiffs might hope. Plaintiff Jennifer Augustus was employed as a security guard for defendant ABM Security Services. ABM security guards are generally required to remain on call at all times during their shifts, including during rest breaks. Augustus, along with two other employees, moved to certify a class of all similarly situated ABM security guards, arguing that the on-call requirement during rest breaks rendered those breaks indistinguishable from normal security work. ABM conceded that security guards were uniformly required to keep their radios and pagers on during breaks and to remain vigilant in the event a need for their services arose. Based on these admissions, the trial court certified the class, holding that ABM possessed a uniform rest period policy applicable to the entire putative class. Following class certification, plaintiffs moved for summary judgment of the rest break claim. The trial court granted the motion, holding that the on-call requirement rendered the security guards subject to employer control. ABM appealed. In reversing the trial court's decision, the Court of Appeal looked more closely at the standard required for provision of rest breaks, holding that California Labor Code Section 226.7 only precludes an employee from being required to work during rest breaks. While ABM security guards were required to remain on call during these breaks, they were also otherwise permitted to engage and did engage in various non-work activities. The trial court's classification of plaintiffs as subject to employer control, therefore, was an insufficient basis upon which to grant the summary judgment motion. While nuanced, this case marks a victory for employers seeking to provide rest breaks in a manner that both meets the employer's needs and fulfills its legal obligations. As always, however, employers are encouraged to proceed with caution and consult legal counsel in situations where an employee may be perceived as having to work during rest breaks. In Dixon v. Burke-Williams, a California Court of Appeal held that an employer cannot be held liable for failing to prevent harassment and discrimination under the Fair Employment and Housing Act, or FEHA, when an employee cannot establish that illegal harassment or discrimination occurred. Dominiqua Dixon filed a lawsuit against her former employer, Burke-Williams, alleging a series of claims under the FEHA arising out of her work as a massage therapist. Dixon specifically alleged that she was subjected to sexual harassment and discrimination by customers, and that Burke-Williams failed to take adequate steps to prevent that conduct. At trial, the court instructed the jury that with regard to Dixon's claim for harassment, she was required to establish both that she had been harassed based on sex and that the harassment was severe or pervasive. However, the trial court instructed the jury that with regard to Dixon's claim for failure to prevent harassment or discrimination, Dixon's burden was simply to establish that she had been subjected to harassment or discrimination based on sex. In other words, she was not required to prove that such conduct was severe or pervasive. The jury concluded that harassment had occurred, but was not severe or pervasive. Relying on the trial court's instructions, the jury found for Dixon on her claim for failure to prevent harassment, even though it found that no liability existed on the underlying claim for harassment. Burke-Williams subsequently filed an appeal on the ground that the trial court's instruction to the jury was incorrect. The Court of Appeal reversed the jury's conclusion, holding that liability for failure to prevent harassment cannot exist where no actionable harassment occurred. As the appellate court explained, it would be anomalous to provide a legal remedy for failure to prevent actions that were not unlawful. Moreover, although the approved jury instructions for the failure to prevent harassment claim did not explicitly state that the alleged harassment needed to be severe or pervasive, they required that the jury be instructed on the elements of harassment, which included the severe or pervasive language. The appellate court extended the ruling to hold that an employer cannot be held liable for failing to prevent discrimination where the employee cannot establish liability on the underlying discrimination claim. This decision is a positive development for employers as it affirms a strong defense to a failure to prevent harassment or discrimination claim. However, the decision also serves as a reminder that employers have an affirmative duty to prevent harassment and discrimination in the workplace. Failure to meet this duty can create an independent cause of action for employees. It is therefore imperative that employers implement and enforce zero-tolerance harassment and discrimination policies. And finally, in Securitas Security Services versus Superior Court, a California Court of Appeal held that all waivers of the Private Attorney General's Act, or PAGA claims, are unenforceable, even if they are not voluntary and not required as a condition of employment. In June 2011, Denise Edwards, an employee of Securitas, signed an acknowledgement of receipt of Securitas's dispute resolution agreement. The agreement, which required Edwards to arbitrate all claims arising from her employment, included a waiver of class and representative claims. Although Securitas provided all employees 30 days in which to opt out of the agreement, Edwards did not do so. In 2013, Edwards brought a class action lawsuit against Securitas in state court, alleging various wage and hour violations. She also alleged a representative claim under the PAGA. Securitas asked the trial court to compel Edwards to arbitrate her individual claims and dismiss or sever and stay her class claims. It also asked that the court dismiss and/or stay her PAGA claim. The trial court granted Securitas's motion to compel arbitration. However, it ruled that Edwards' PAGA claim could not be waived and that because the agreement's class action waiver provision illegally sought to eliminate or abridge Edwards' right to litigate her PAGA claim, that entire provision was invalid. Accordingly, the trial court ordered the parties to proceed with arbitration as to Edwards' entire complaint, including her class and PAGA claims. Securitas appealed, arguing that the California Supreme Court's decision in Ascanian v. CLS Transportation only invalidates PAGA waivers within mandatory arbitration agreements. Securitas maintained that because Edwards had the express right to opt out of the agreement and declined to do so, she voluntarily consented to the PAGA waiver. The appellate court disagreed, holding that Ascanian's holding required it to conclude that the PAGA waiver was unenforceable. The appellate court then analyzed the entire agreement and determined that the provision waiving class and representative claims could not be severed from the remainder of the agreement, per the mutual intent of the parties. As such, the agreement was unenforceable in its entirety. The appellate court accordingly directed the trial court to vacate its order and enter a new order denying Securitas's motion to compel arbitration. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jlayton@petitcone.com. That's all for this quarter's legal update. Thanks for tuning in.